Yes, yes. Good morning, students. This is VK Sinha, the senior faculty member of Pahuja Law Academy, taking a variety of subjects in this institution. You see, we are taking up jurisprudence, constitutional law, administrative law, international law, and above all, we are also taking every week, current issues. Today, this particular address is related to one of the most important subject matter of jurisprudence, and this most important subject matter of jurisprudence is related to schools of jurisprudence. This subject matter is perhaps the base of the entire subject matter. Schools of jurisprudence. This is schools of jurisprudence, you see. Schools of jurisprudence, to begin with, you see. Actually, there are different schools of jurisprudence. Number one is the analytical school of jurisprudence. Number second is natural law school. Number third is historical school of jurisprudence. Number four is sociological school, and number five is ethical school. And the last one is that is known as realistic school of jurisprudence. Now you see, these are the different schools of jurisprudence. These are the different schools of jurisprudence. In other words, you can say that these are the different approaches. These are the different approaches. These are the different approaches to the treatment of jurisprudence. These are the different approaches to the treatment of jurisprudence, you see. These are the different approaches to the treatment of jurisprudence, you see. And these approaches are represented by these different schools. These approaches are represented by these different schools. So each school, in this connection, each school lays emphasis upon different aspects of jurisprudence, so as to explain the rise of the content of law in this subject matter, you see. So the approaches lays emphasis upon the different aspects of jurisprudence, and each aspect has been converted into different schools of thought, you see. So let us start with the first school, that is analytical school. Now this is the most important school, which is known as analytical school of jurisprudence. This is known as analytical school of jurisprudence. Now this analytical school of jurisprudence has different nomenclature, you see. First of all, this school is known as positive school of law. This school is known as positive school of law. And it is positive school of law because, you see, because the exponent of this school are concerned neither with the past nor with the future of the law, you see. The exponent of this school is concerned with law as it actually exists, you see. So the law which actually exists, you see. You see. So when we say that the law which actually exists, we mean that this is a positive school of law, and in other words, you can say that this positive school of law therefore lays emphasis upon the state made law, you see. So under this head, you see, the main suggestion, the main message that is being given here, you see, the message is very clear, you see, that in every state, in every sovereign state, there is a legal, independent and political superior. There is a legal, independent and political superior who makes the law, you see. So which is, in nutshell, this is called state made law, you see. And this state made law, on the basis of this concept of state made law, you see, this analytical school of jurisprudence is also called, you see, this analytical school of jurisprudence is also called the positive school of law. तो एक इसका नाम हो गया positive school of law, you see. एक इसका nomenclature है which is known as positive school of law. That is the law that is the law that is actually exists, you see. Second, इसका दूसरा जो नाम है, the second name. So to start with, let us understand the different nomenclature of this particular school. The second name in this connection is that this is also called imperative school of jurisprudence. This is also called imperative school of jurisprudence, you see. And this is also called imperative school of jurisprudence, you see. Now the question that emerges here, in this connection, the question that emerges, that why this is known as, this first school is known as imperative school of law, you see. Why this is known as imperative school of law, you see. Now imperative school of law, I mean, it is so said, you see, that this school is known as imperative school of law because this is based on command theory, you see. This is based on command theory. Command theory, that is obedience of command. Actually, according to this imperative school of law, obedience to command, obedience to some kind of command is law, you see. Obedience to some kind of command is law, you see. And this command emanates from a particular political, legal and independent superior. A particular legal superior and independent and a political, legal and independent superior that is sovereign, you see. So this approach is described as imperative school of jurisprudence. And the best exponent of this school was, I mean, John Austin, you see. John Austin had given a statement, you see, that law is the command of the sovereign. So according to John Austin, this imperative school, I mean, consists of three important things. One is command, the other is sanction, and the last one is sovereignty, and the last one is sovereign, you see. So these three, these three elements taken together, constitute an imperative school of thought. Imperative means some kind of coercion, you see. Imperative school of thought. So you can say that this first school is also known as imperative school of thought, you see. This is the, second important name is school ka second. This is the second important nomenclature, you see. The third, this school was dominated in England. This school dominated in England. So sometimes this is popularly known as English school. Sometimes this is also popularly known as English school. And the main proponent of this English school was Jeremy Bentham and John Austin. Jeremy Bentham and John Austin, you see. Jeremy Bentham and John Austins are actually the forerunners of this school. So sometimes they are called, and so sometimes this school is also called Austinian school of jurisprudence, you see. So this is also called Austinian school of jurisprudence, you see. Austinian school of jurisprudence, you see. So you see what I'm trying to say in this connection, you see. What I'm trying to say in this connection, that this analytical school of jurisprudence is known by different names, you see. One is the positive school of law, the second is imperative school of law, and the third is Austinian school of jurisprudence, you see. And similarly, Salmon also in this connection terms this school as a systematic school. सैलमोन ने इस स्कूल को सिस्टमेटिक स्कूल कहा, सिस्टमेटिक स्कूल, systematic school, and Salmon terms this school as a systematic school. Systematic school because you see, systematic school because in this connection, and he actually, and this systematic school and claims, this systematic school claims to be real, logical and scientific, to be real, logical and scientific, and in the study of law, real, logical and scientific in the study of law, you see. And similarly, the last but not the least, you see, this school is also known as analytical school of jurisprudence. This school is also known as analytical school of jurisprudence, and this is analytical school of jurisprudence because this school seeks to, analyze, and seeks to analyze the basic legal concepts of, the basic legal concepts, the basic legal concepts of jurisprudence, you see, the basic legal concepts of jurisprudence. So this analysis of the basic legal concept of, concept of jurisprudence, this analysis, has also, converted into, this analysis has been converted into this analytical school of law. So you see, the what I am trying to, put up in the beginning, you see, what I am trying to put up in the beginning, I am trying to put up in the beginning is that, you see, and there are different approaches. And this is what I am trying to put up in the beginning, you see, that there are different approaches. There are different approaches to the treatment of jurisprudence. There are different approaches to the treatment of jurisprudence, and each approach in this connection, has been converted into, different schools, has been converted into different schools, because each approach, each school, each approach has emphasized upon different aspects of jurisprudence, you see. Say for example, you see, and for example, in this analytical school of jurisprudence, you see, the 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 emphasis is on state-made law, you see. The emphasis is on state-made law, you see. In natural law school, the emphasis is on, basically the emphasis is on certain moral principles which are not created. These moral principles are discovered, you see. These moral principles are discovered, you see. These are discovered, you see. And these, moral principles are universal in application. Universal in application, you see. These are universal in application, you see. So natural law school is emphasizing upon this particular aspect, you see, because it is talking about an ideal law in an ideal state, which is universal in application, which is applicable to the entire mankind or the society, you see. Similarly, historical school seeks to explain seeks to trace the growth of law, the evolution of law, you see. The growth of law, the evolution of law. Similarly, the sociological school seeks to explain the relationship, the inherent relationship between the law on the one hand and society on the other. Law influences the society and society influences the law, you see. So what I am trying to say, this much, that there are different approaches, you see. There are different approaches to the treatment of jurisprudence, you see. And these approaches are represented by you. And these approaches are represented by you see. And these approaches are represented by different exponents and different schools. Each approach lays down a particular emphasis on a particular aspect of jurisprudence, you see. So I started with the first one, analytical school of jurisprudence. I started with the first one, analytical school of jurisprudence, and this analytical school of jurisprudence has different nomenclature, you see. It is known as positive school of law, number one. It is also known as imperative school of jurisprudence, number second. It is also known as imperative school of jurisprudence, number second. It is also known as Austinian school of jurisprudence, number third. It is also known as systematic school of jurisprudence, number four. And it is also known as analytical school of jurisprudence, number five, you see. So the purpose in the beginning is to suggest. So the purpose in the beginning is to suggest that these schools and the persons, the jurists concerned with these schools have adopted different method, different approaches to the study of law, to the study of jurisprudence, you see. One such important school is analytical school of jurisprudence, which is known by different names, you see. One such important school is analytical school of jurisprudence, which is known by different names, you see. Now this school it lays emphasis upon, as I told you just now, you see, this school lays emphasis upon the law that is made by the state, the law that is made by a political, independent and legal superior or sovereign, that is a state-made law, you see. This school in the beginning believes, that this school emerged as a reaction against, you see. This school emerged as a reaction against the natural law school. And the basic premises of this school is, that this school primarily deals with law as it exists. You see. And it exists in the present form, you see. In the present form, that is the existing state-made law, you see. That is the existing state-made law. So the exponent of this school treat and law as command of the sovereign, law as command emanating from a political and a legal and independent superior or sovereign, that is the state, you see. So the advocates of this school. So the advocates of this school is neither concerned with the past of the law, is neither concerned with the past of the law, nor it is concerned with the future of the law. It is concerned, it is concerned, Hannah, it is concerned, it is confined to the study of law is as it actually exists. Law as it actually exists. Law as it actually exists. And this, concept law as it is actually exist is known as positus. इसी को हम लोग कहते हैं positus. Positus. This is known as positus. This is known as positus, you see. So it is for this reason. It is for this reason that this analytical school of jurisprudence, it is for this reason that this analytical school of jurisprudence, is known as the positive school of jurisprudence. Is known as the positive school of jurisprudence, you see. Positive school of jurisprudence. And Jeremy Bentham and John Austin, are the forerunners of this school. So it is also known as Austinian school of jurisprudence. Now if you see, this is the basic premises of. This is the basic premises of the basic proposition of this first school, that is positive school of jurisprudence, or you can say imperative school of jurisprudence, or you can say analytical school of jurisprudence. And this is the basic proposition of this school, you see. Now it is said that this school, as a matter of fact, had some motto, you see. This school, as a matter of fact, has some basic motto. This basic motto, if you see this basic motto, and अगर आप इसका motto, if you see the motto, basic motto, तो इस स्कूल का जो basic motto था, the motto is ubi civitas ibi lex. This is the basic motto. इसका मतलब ये हुआ, it means that where there is a state, you see, it means that where there is a state, there will not be anarchy, you see. Where there is a state, there will not be anarchy, you see. Yani if you go through this connection, and agar aap dekhiye, if you go through, in this context, we can say that, that the ultimate message is that the state is a necessary evil. There is a famous statement by Thomas Paine ने एक famous statement दिया है that the state is a necessary evil. State is necessary, although it is evil because it intervenes or interfere into the life of the people, you see. State, so there is a greater emphasis upon the state made law, and in this school. This is the basic premises of this school. Thank you very much.